Good afternoon and welcome to the BRR Legal Brief, looking at the major legal issues affecting corporate Australia. I'm David Bushby and today we're talking superannuation reform, and in particular we're looking at the ASIC's latest announcement which came through late last week on the Stronger Super Reform Package. Here to discuss the announcement and what it means for the super industry is John Edstein from the superannuation team at King Wood Mallesons. Welcome, John.
Thanks, David.
John, just to kick us off, we've seen the announcement come through late last week. It was a fairly lengthy announcement, but just to recap, where are we at on superannuation reform and how does this announcement build on that?
Yes, thanks, David. We're actually in the crunch year for what's called the Stronger Super reforms. In terms of most of them will bite in terms of application going forward from 1 July next year. In terms of legislation, we've got precious little that's actually been signed off, you like, into law, but a lot of either draft law or bills or draft prudential standards kicking around. In terms of the ASIC website release last week, it did puzzle me somewhat in that the three regulators that have a role in Stronger Super go back APRA, ASIC and the ATO. And literally between those three, APRA is far and away the centrepiece regulator. ASIC it certainly has a role, as does the ATO, but APRA is clearly the main regulator. And I should add, these Stronger Super reforms, they date back to a lot of people will be familiar with the Cooper Review. They put in a report into the government, led to put recommendations to the government. Some were accepted, most were accepted, some rejected by the government, and then the rest has followed.
Well, the ASIC release also talked a lot about, I guess, a regulatory timeline for documents.
Yes.
So what, I guess, can we expect from ASIC on that front, and when are we expecting to receive it?
That's unclear, and I can't say even on the law at this stage, and I don't think ASIC knows. They defer to when the regulations come out, because a fair chunk of this work relates to materials that we're still waiting to see in regulations. ASIC's main role is going to be around disclosure and around the registration of auditors for SMSFs, none of which we've got clear details on. To be fair, I think obviously they're important things, but they are definitely subsidiary to the main game, I think, that's happening over with APRA and APRA's oversight, which is we're right into now. And APRA's put out timelines. This is at the large fund end of town, if you like, where the trustees need to be thinking about whether they're building this thing called My Super. And in fact, just to pick up on the ASIC website, they identify, correctly in my view, the three main things that are coming out of Stronger Super are this thing called My Super. It's the new prudential oversight, if you like, so it's raising the bar on the prudential oversight of superannuation funds generally, not just the big end of town, but SMSFs as well. And then also this thing called SuperStream, which is all about efficient information flows. And the ATO is the main leader on that, although ASIC will probably have a role. So that's where we're at. And right at the moment, we've got the large funds particularly grappling with building My Super, what's it going to look like, adjusting their systems, their structures, their trust deeds, all those sort of things, because the My Super thing, to run a My Super product, you have to have an authorisation from APRA, licence if you like, but it's so that there's a process to go through with APRA.
Well, I guess the next question is there's things coming out from, I guess, APRA, from the ATO and now ASIC. Yes. From what you have seen so far, are there any major issues or concerns that you've come across?
Oh, where do I start?
Yeah.
The biggest thing that I think is there, and this is at super high level, is that for trustees of non-SMSFs, if you like, the SMSFs are in a not work to rule, but just work through things. But the bigger funds, the non-SMSFs, they've got so much on their plate ahead of them to get through, to get to the 1st of July next year. And if they haven't got a plan in place to get through all that, then they seriously need to get onto one very, very quickly and then work the plan. We were talking earlier, but we've been doing presentations for boardrooms. In helping there, I mean, there's many ways to get to the top of the mountain, but we actually put together what we call top-down planning and just went right through all the legislation and the things that have to be thought through. And it's mind-numbing.
Can you pick out a couple of those major issues or major barriers to get through in order to get
Well,
prepared?
the MySuper is the big one.
Yeah.
Okay, so that's just hugely out there. The other big one that's sitting with trustees of super funds, which is partly MySuper, but it's much more extensive than MySuper, and that is APRA under the Stronger Super reforms has been given a lawmaking power, prudential standards they're called. And it's written in draft at this stage, prudential standards across 11 areas, okay? And basically every super fund has to develop policies to comply with these prudential standards. Now that's, some people might think, oh, isn't that just a matter of getting your lawyers to write something up and putting it in the drawer? But these are trustees of super funds. They have fiduciary responsibilities, not to mention their regulatory responsibilities. So these are things that, and a bit like the other point I made, there's many ways to get to the top of the mountain. So directors, responsible directors need to say, when we're looking at our governance, we're looking at our risk management, we're looking at outsourcing policies, fit and proper policies, remuneration for directors, all those. We should be debating those things, discussing them, formulating a policy. Then it gets committed to words. Then we review the words that we've got in our policy. And then by the 1st of July next year, we have to have that implemented, not just written.
Yeah.
We have to be executing against it. You do your timelines on that, throw into that business as usual work. In fact, before I came over here, I was talking to a client. What tends to focus the mind for organisations say, oh, we don't want to do that, so we better restructure. So we will get some consolidation of super funds, I think, over the next 12 months. And that's just an additional piece of work that comes on because of the regulatory compliance.
Well, I guess just following on from that, and I guess just finally, there is so much to do from what you're saying.
Yeah.
And then looking at the ASIC release, there's a lot of consultation that's upcoming.
Yeah.
We've got the roadshow to look forward to.
Yes.
But there is a to-do list.
Yes.
I mean, should we be participating in that consultation, and then there's roadshows, or really should we be getting on with the job?
Look, I think the government's view and that of the regulators would be definitely getting on with the job. I mean, unfortunately, it's become the nature of things these days. FOFA is another good example, where we get things in tranches and they're still not law, but we've got deadlines coming up. If you're not trying to work up something now, you are seriously behind the game. I was at a presentation recently where APRA was speaking and they were making the same noise. The full expectation is, even though laws are draft, you should be on with the game now.
Well, some great insights. We'll certainly look forward to cracking the whip on the industry and making sure we're ready for that deadline. Thanks again for your time today, John.
Pleasure. Thanks, David.
And viewers, thank you for tuning in for this week's Legal Brief. We look forward to having you tune in for next week's episode.